You're unhealthy to be driving a vehicle. You're illegal to be driving a vehicle. You're operating a vehicle with methamphetamine in your system. You flee and elude. You're reckless driving. Our next file this morning is the state of Michigan versus Wayne Kodishka. This is file number 25-3618-FH. Appearance, please.
David and Hunt on behalf of the people.
Your Honor, Hariah Davis, on behalf of Mr. Kubishka, who's present and seated to my right.
Thank you. Also here this morning is Ms. Laura Odell. She is the agent from the Michigan Department of Corrections that is prepared today's pre-sentence investigation report. One moment here is I pull that copy from my stuff. All right, there we go. All right. I have my copy of the pre-sentence investigation report. Let's take a look here, see if we had any changes. Right. We are here today in which the defendants pled guilty to a single count of possession of controlled substance, methamphetamine. I look at offense variable number 12. Currently it's scored for more. Now it appears to be scored at 5 points, which my concern here was the flee and elude as well as the tampering, which would make 3, but it's not, those are not contemporaneous. So then they're not crimes against a person. Another question here is that I look at OB 19 as to whether or not there was any issue regarding administration of justice. 1 second. All right, I'll disregard that. Let me take another quick look here at my note. I guess I don't have anything. Mr. Denman, go ahead.
Thank you, Your Honor. Again, to discuss OB 19, that was the one objection to the scoring that the people had, the interference with administration of justice, as the PSI report indicates. There was an attempted traffic stop for.
Yeah, that's right. I was pausing and I couldn't find my note. Yeah, I'm looking now on CFJ 284, page 2, and I see my note there. The defendant accelerated, because I know I talked about the flee and elude when I mentioned OV 12. Clearly, he had at least 2 other felonies, but they weren't crimes against a person. So the question here is attempting to avoid being pulled over. Go ahead, sir.
Yeah, and I believe it's more than that. So at the time that he was attempted to being stopped for the tinted windows, he accelerated, and he also threw, and this was.
So he attempted to destroy the evidence.
Yes, he
Yeah.
threw both a pipe and I believe it was a baggie of methamphetamine. So for those reasons, we believe that OB 19 should be scored at 10 points here.
All right, Mr. Nagos, your response, sir.
I wish I had more of an argument. I don't think that my client disputes the fact that he did in fact accelerate and rapidly, in a rapid fashion and turn, but unfortunately, I don't have a argument against it. Discarding of the evidence as my client's statements and the PSI confirms those were in fact his actions that gave rise to the underlying conviction. So because of that, I think OB 19 is properly scored at 10 points.
All right, so we're going to score OB 19 at 10 points. I believe this court makes a finding by a preponderance of the evidence based upon the information contained in the pre-sentence investigation report. And I don't need to look too much further than the statements obviously made here that are reflected to be from the deputy, but also even from the defendant's son that was in the passenger seat. Therefore, the court will add 10 points to OB 19. That brings us to a total OB level of 15 points, which I'm pretty sure is going to make this an OB level 2. I'm going to make it a 0 to 9. Let's take a quick look. Yep, so that's a 0 to 9 1. All right, thank you. Anything further, Mr. Denon? Thank you. Mr. Nagos, any amendments, corrections, or objections to make?
No, yeah.
Thank you. Allocution then, Mr. Nagos.
If my client's approximately 60 years old, the information in the report is otherwise accurate. He maintains the fact, and while I acknowledged before you that he did test positive while on bond a few months ago, that stemmed from the consumption prior to the date of his arrest. He's been clean since then. Obviously, his limited criminal history spans back primarily decades ago. I would ask for the court to follow the recommendation, and I will fall on the sort of ignorance in the court's typical preference in treating these cases. And I would simply ask whether the court believes that a 24-month period of probation is necessary for a client under my client's facts and circumstances. I would ask for the court's grace in considering a shorter period of probation. If the court chooses to go along with the 24 months, certainly my client stands ready, willing, and able to complete probation along with any conditions the court sets for him. Thank you.
Thank you. All right, Mr. Denon.
Thank you. People do support the recommendation. People believe that the defendant may benefit from substance abuse treatment. We think the recommendation is well balanced. We've discussed a little bit about the incident. I think it's also worth noting that it was a significant quantity of methamphetamine. It was 15.6 grams. So it's a significant quantity. This is the defendant's first felony. And we do support the recommendation. We would respectfully request the court follow the recommendation.
Thank you. Ms. Odell, do you know, did you come across anything in his history that showed that he had a CDL, commercial driver's license?
Yes, Your Honor. Agent Blazak looked into that, and driving records and lien do indicate that there was a valid CDL at one point.
At one point. So I'm looking just because it says here he doesn't have a license. In fact, he provided.
So
he said he doesn't have a valid license.
Right.
All right.
I guess I'm not sure what Your Honor's.
I'll get to it. Thanks. Sir, if you wish to make a statement, now is the time. Is there anything you wish to say today? No. All right. Well, I'll tell you what. I don't agree with the recommendation. Let me tell you how I assess this case. You and your son were out doing meth and driving around and weed in a car. You don't have a license. And here's why I asked about the CDL. Because right below that, 2 lines below it, it says here you were a truck driver. Maybe you were, but you lost your license. You don't have a vehicle. And I'm going to tell you another thing. When I looked at here on the back of this information, on CFJ 284, page 9, the defendant asserts claim that he owns a 2001 Ford 350. Is that car registered?
No, sir, it is not. I just,
Good. I hope not, because you can't drive one. I've got no idea why you would own one unless you're just driving around in circles on your property.
okay, can I say something about the CEO?
Sure.
Okay. I come off the road and my partner blamed me for stealing a pickup truck,
Okay.
okay? I had 5 stents and a defibrillator put in Florida.
Oh, and I'm gonna get to that.
And
Go ahead.
I couldn't get up here to the court, okay? So that suspended my driver's license,
Okay.
okay? I just, last month, took care of that and they dismissed it because I didn't steal it. It was in my name.
All right, so here's the point. That is merely a ridiculous excuse. You shouldn't even have said anything right there. Let me tell you why. You know you knew you did not have a license, which means you should not have been driving your son's vehicle, even though your son was right next to you. And your degree of negligence, you should not be driving a car. Why? Because as you just mentioned, and then there's one of the things of your medical conditions you left out. All right, you get a couple issues of diabetes. I've got type 2 diabetes. You've had 5 heart stents. You've got a defibrillator, back issue, and there's one more that you missed. Being half blind. You should not have been driving. And your age today certainly doesn't help you. 60 years old. So already this night, you were up to something stupid. So let me keep going. By the way, tell your son, don't have tinted windows. I am absolutely dumbfounded by people who have tinted windows. They are illegal. It's like shade that you can have over a certain depth down the window. If you're driving a car, tell your son he's an idiot. Okay? Now, accelerated rapidly when the officer tried to stop you. Driving down West Sanborn Road erratically. You didn't get charged with a flee and elude. I don't know why. You didn't get charged with a reckless driving. I'm sorry, maybe you did, but they're gone. Yeah, they may have been dismissed, but still, you got no reckless driving. Not only you shouldn't have been driving, and because you don't have a valid license, I like this one. Here's another one of your health conditions. Your feet go numb. So you're medically unable to should be driving a car. You are a danger if you are ever behind a vehicle. Anybody coming in here today and thinking I'm going to look at a 6-year-old man and go, well, no, he's not going to get jail is wrong. You're going to go to jail in a couple minutes. You shouldn't be driving a car. Now you've got one heck of a deal. Multiple other felonies, multiple other misdemeanors, illegal transport of marijuana in a vehicle. That also should have been on there. Methamphetamine residue. And by the way, this highlight, there's one other argument that your defense counsel made that was not well thought out. That was that you tested positive. And why did you test positive, did he say? Because you had it in your bloodstream when you got stopped. That's driving under the influence. So you're unhealthy to be driving a vehicle. You're illegal to be driving a vehicle. You're operating a vehicle with methamphetamine in your system. You flee and elude. You're reckless driving. Meanwhile, your son was right there next to you. Oh, and by the way, while I can't punish you for this, he also lied and tested positive. So you are a very bad example as a father, because you and your son were out driving, doing weed and smoking dope and doing methamphetamine. And you fled the cops. So I look at your prior criminal history, and yeah, because of between 2001 and 2014, you have a 10-year gap. But let me take a look at what you have had in your past. All right, so you had some prior driving license suspendeds. And by the way, that was back, there's one here back in 1988, and now you were driving without a license. So you never learned your lesson there, and you're going to do what you think you want to do and can do when you think you're not going to get caught. You had, in 2001, a driving under the influence. Let me tell you, ask it, does this sound familiar? Under the influence of alcohol and drugs. Oh my gosh, that's exactly the same thing. Well, it wasn't alcohol. It's the same thing you were doing here. Huh. Well, then you get another driving under the influence in 2014. Then in 2025, you pick up our cases. And it looks here, and I can tell, for about a year, you were using methamphetamine daily. And although it's legal, marijuana, however, it's not legal to drive with it in your system. I don't know if it was in your system, but there were burnt roaches inside the vehicle. So now it says here you went to some AA. You don't know when you started and you don't know when you ended. That tells me that AA or NA was not really all that important to you. And when I look here on CFJ 284-9 or 284 page 9, I look at all these medical issues. First of all, there's nothing in here about medication or treatment. So I'm just going to assume, because nobody really talked much about it, that you probably aren't taking care of your conditions. You have respiratory issues, hypertension, diabetes, back and joint pain, back interference, arthritis, half blind. And then your defense today was that somewhere down the road in your past, somebody told you, somebody screwed you over by you having to take the blame for something. Yeah. No.
Your Honor, may I?
Nope. You're done. You had your time to make an appeal or make your pitch.
Respectfully, Judge.
Yeah.
Based on the court's commentary that on 0 to 9, you intend on putting him in jail, I'm just asking for appeal purposes, understanding that you've laid out your thoughts to specifically indicate what it is that the presumption in this case is such that he needs to go to jail. And in addition, in terms of the physical health, in the physical health narrative, he, quote, provided a list of medications that he's currently taking.
Just a second. Nancy, did he ask me a minute ago if we could talk? I think I told him no. Mr. Negos, sit down.
Yes, sir.
So I have the right and responsibility because there is a reasonable presumption. And I've covered that. And it isn't because you have the medical issues. It's because you have the medical issues and you were driving a car high, fleeing police, driving reckless. Yeah. You're guilty of multiple crimes that night. And you threw the evidence out. Thankfully, your son told the truth. Mr. Diegos, you're really lucky you're not going to go back with your client tonight. Thank you for today. Now, I always offer people at the end if there's anything else they would like to say. You don't get to do what you just did. All right?
Yes, sir.
I asked questions. I gave you all the time to talk. When I talk, it's my turn to talk. I gave you all the right respect to let you guys make a pitch. I've established my grounds for reasonable grounds, and I've also have established the proportional and reasonableness of this offense. The court places the defendant on a period of probation that will be for 24 months. The defendant has the right to be considered for early release from that probation if he's successful with the terms or conditions that will be set at halftime. The court adopts the terms and conditions for probation that are listed on CFJ 145 pages 2 and 3. I find that those are well suited for rehabilitative purposes. Specifically, the terms and conditions regarding alcohol and other intoxicants, which includes recreational marijuana, and definitely includes methamphetamine, are reasonable based upon the issues here. The defendants had prior operated while under the influences. Here, according to the own testimony from his counsel today, was that he tested positive only because he still had it in the system when he got pulled over. The court assesses a $68 state minimum fee, a $130 crime victims' right fund fee, a $300 cost, a $500 attorney fee, $500 fine, and a $300 attorney fee. There will be supervision fees of $30 a month or $60 a month if there's any electronic monitoring. I think we had to do DNA here, so that's a $60 DNA fee payable to the Missaukee County Sheriff Department. The court finds, as I've already mentioned, reasonable grounds. The defendant was out there putting people in danger, and the court sentences the defendant to 120 days, and the defendant receives 3 days of credit. All fines and costs are payable and due within 56 days, or a 20% penalty will be added. The court will not assess that 20, or actually with a better phrase, will waive the 20% penalty as long as the defendant is paying during the terms of the conditions of probation. All right, Ms. Odell, have I missed anything?
No, Your Honor, thank you.
Mr. Denham,
No, Your Honor.
Mr. Diegos, now if you have something to say, you may say it.
No, Your Honor, thank you.
Thank you. We are adjourned. Oh, wait, hold on. Sorry, I forgot. Madam Clerk, please state this out. Mr. Kabishka, you are receiving 2 copies of one document. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal must be done by filing an application for leave to appeal. Now, if you choose to file an application for leave to appeal and you want the court to consider appointing an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Thank you very much. We are adjourned.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.